joining me. My name is Marc Fitapelli. I'm a New York City-based attorney and the owner of MDF Law, a national law firm with offices in New York and California. Together with my partner, Jeffrey Saxon, we represent consumers nationwide who've been financially injured, people who lose money in cryptocurrency scams or investment scams. I'm here today to talk with people who may have lost money in a Delaware Statutory Trust. And what I'm going to do in this video is I'm going to give you a brief overview of what Delaware Statutory Trusts are, the key features of the investment, and what you could do if you invested in a DST as part of a 1031 exchange and the investment may not be doing well, what your legal recourse might be in that situation. So before I get into that, just a brief disclaimer. This video is attorney advertising, and if you have any legal issue or legal problem, I encourage you to call me or to call any other attorney who's licensed and competent and who could handle your issue. Don't just rely on videos that you see on the internet. So with that disclaimer, I'm going to just talk with you now about what Delaware Statutory Trusts are before I give you the options for what to do if you have problems with them. So if you're watching this video, you probably already know what DSTs are, but just for the benefit of people who may not know what DSTs are, DSTs stand for Delaware Statutory Trusts, and people who invest in them for a variety of reasons. I'm talking with people just who invest in them for 1031 exchanges. And we use Delaware Statutory Trusts for 1031 exchanges because there was an IRS revenue ruling many years ago that said that in order to qualify for a 1031 exchange, you could use these Delaware Statutory Trusts. And what's important about the IRS revenue ruling isn't that they're Delaware Statutory Trusts. It's that in order to do a 1031 exchange, investors have to give up a certain amount of control to do these transactions with Delaware Statutory Trusts. And that's what the IRS revenue ruling says, essentially. There are a lot of technical requirements, but essentially it all comes down to giving up a certain amount of control for the property. And if you meet the standards in that revenue ruling, and Delaware Statutory Trusts are one of the vehicles that do that, you can take advantage and you can do a 1031 exchange, right? The problem with all of this, of course, is that you no longer own a piece of real estate and you've given up substantial amount of control, right? And when you did this investment, you thought that that was a good thing because you're not dealing with tenants and toilets anymore, if that's what you were doing before. Now you have a professional management company that's dealing with your property. So you were sold something that you thought was going to be much easier, but the rub to it is that you gave up a substantial amount of control in order to do this DST investment. And so now that things have gone wrong, you may be asking yourself what you could possibly do. And unfortunately, your options for suing the trustee are usually limited, and that's usually a dead end in my experience. And it's usually often very difficult, even if there's self-dealing, and even if there's allegations that the trustee or the investment sponsor is converting or stealing money. Unfortunately, I've been involved with and I've seen cases where investors have even been sued by investment sponsors for trying to bring claims just because of the structure of the Delaware Statutory Trust. So, whether or not you want to do that is up to you. I'm not here to talk about suing trustees or your recourse in that regard. I'm here to talk about suing the 1031 company that put you in the investment to begin with. And that's what my law firm does. We sue, and they're not 1031 companies, they're broker dealers and they're licensed financial advisors, the people who sell 1031 exchange interest, the people who sell DSTs. And that's an important point that I want to emphasize. And the point is that when you buy DST interests, you're not buying them from a real estate broker and you're not buying them from a qualified intermediary. You're buying them from a licensed professional that's licensed with the Securities and Exchange Commission or licensed with FINRA. And the reason why that is because about 20 or 30 years ago, the National Association of Realtors wanted TIC interest and wanted DSTs, or the precursors of DSTs, not to be regulated by the Securities and Exchange Commission. And there was an extensive lobbying effort by the National Association of Realtors, but they lost. And what ultimately happened is the Securities and Exchange Commission and the securities regulators nationwide decided that Delaware Statutory Trust interests and these securitized 1031 interests are things that are securities and they're not investments. And because of that, we have to have special licensed people sell these products to you. And when these special licensed people sell these products to you, it carries with it certain obligations. And so that's my next point is if you bought one of these products through a licensed financial advisor, and if you're in a DST, you did buy it through a licensed financial advisor in all likelihood. If you bought it through them, they have legal recourse, or you have legal recourse against them for their failure to do due diligence in the offering. And what I want you to understand is that when you purchase that DST through the 1031 company that, remember, wasn't the QI, right? It was a broker. They were paid a fee. And that fee wasn't just a broker's fee or a finder's fee. That fee has strings attached under the law. And some of those strings have to do with due diligence. When you purchase a Delaware Statutory Trust, there's no IPO, right? So it's sold to you pursuant to an exemption under the securities regulations. And because that exemption exists, what happens is that the salespeople who sell these investments, they're required to do due diligence. They are legally required to do what the Securities and Exchange Commission would essentially do for an IPO. So when a company does an IPO, they give all their disclosures to the SEC. The SEC reviews them for their adequacy. There's a comment period. And there's some level of comfort that the SEC has reviewed what this company is putting out there. When you buy a DST, that's not what happens. When you buy a DST, an investment sponsor files a 2-page sheet of paper with the Securities and Exchange Commission, and the sheet of paper is called Form D. When they file Form D, that's it. And all that is it's a notice requirement. They're putting the SEC on notice, and they're saying, SEC, we're going to start selling these. That's all that they're required to do. After they do that, they have to produce a document that has all the material risks associated with the DST, right? And I'm sure that you've seen that document. It's a very thick private placement memorandum, and that has the track record of the investment sponsor, all of the fees, if there's any litigation against the investment sponsor. And so what the investment sponsor of the DST does is they give that to the broker-dealer that's paid a commission, and the broker-dealer under the securities laws has to kick the tires, and they have to do due diligence on the investment sponsor, and they have to make sure that all the things that are said in that document are true. And part of what they have to do as part of their quote-unquote reasonable due diligence is they have to do an investigation into the investment sponsor, right? Do they have a track record? Are the things that they're saying about their track record in this document true, right? Are they giving financial statements? Are the financial statements audited? Are they being audited by someone who's reputable, right? Or if they're doing real estate deals, are the terms of the real estate deals commercially reasonable? If you have a mortgage, is it a balloon mortgage? When is the balloon mortgage being due or becoming due? Are there tenants? When are the tenants' leases due? Are the leases expirations coinciding with the expirations of the mortgages, right? And so what we find ultimately when we get in and when I dig into these DST investments is that these almost overwhelmingly are extremely poor investments for some of the reasons that I highlighted just before. You know, you look at them and you find that you'll have tenants that have relatively short-term leases in some of these buildings, right? You'll have an anchor tenant whose lease expires in 5 years, and then you have a balloon mortgage that has to be refinanced within the similar time period. And so sometimes what will happen is that the investment will go into a death spiral where the tenant leaves, the balloon payment becomes due on the mortgage, the DST group can't get a new tenant in, and if you can't get a new tenant in, you can't refinance the mortgage, and then that's it. And in my experience, that's what happens with a lot of these DST investments, that a lot of them fail just because of poor packaging, right? The investments are just packaged in a way that they're designed to fail, and they're just poor business deals, right? So that's the number one thing that we see, is that the DSTs are poor business deals, right? And they just don't, the offerings just don't make sense from a business perspective, right? And the second thing that we see is that the DST offering doesn't make sense for you as a taxpayer, right? And remember, you're doing these investments because you're trying to defer your capital gains tax, right? So what the broker or the salesperson has to do for you is they have to sit down with you and they actually have to understand what your tax basis is and what your tax liability is. And they should do a calculation for you that weighs your tax liability with the fees that are associated with these offerings. And, I can tell you that when I get into these offerings and when I do those calculations with the client's tax professionals, I see more often than not that your tax liability is often less than what you pay in fees to go into these investments. And that's just because of the way that these investments are packaged. And there are fees on top of fees on top of fees, where you'll have someone who sometimes will go out and they'll source a property. They'll get paid a spread. So they'll source a property, and let's say they buy the property for $10 million. Well, then they'll sell the property to the DST group for $12 million. And then the DST group starts paying closing costs, and those all start to get baked in. And those costs are in addition to other brokers' fees and other legitimate costs. And so when you start to unpackage these DSTs and peel out those layers of costs, you start to understand, maybe this client would have been better off paying a bill to the IRS and investing their money in something different. And so that's the other area where we look at when we look at the adequacy of the broker's due diligence. So when we look at those two things, the due diligence of the investment sponsor and the due diligence of you, right? Did this investment make sense for you from a tax perspective and also from a risk perspective? Is this something that you need or want as an investor from a risk perspective? After we do that, that forms the basis of a claim against your brokerage firm.